Imagine a scenario where a Texas judge steps in to halt fundraising efforts aimed at supporting Democratic lawmakers who are trying to avoid attending legislative sessions. This isn't just any legal maneuver. It's a high-stakes battle that could reshape the political landscape in Texas. But here's where it gets controversial. The judge's decision to freeze fundraising by Beto O'Rourke and his nonprofit, Powered by People, is based on allegations of deceptive practices, a move that could have far-reaching implications for political fundraising in the state. On Friday, a Texas judge issued a temporary restraining order, TRO, in Tarrant County, temporarily blocking O'Rourke and his organization from using political donations to support quorum-breaking Democratic lawmakers. This action came after an emergency hearing where Attorney General Ken Paxton's team argued that O'Rourke's group had raised funds through false, misleading, or deceptive acts in violation of the Texas Deceptive Trade Practices Act. Paxton emphasized that a planned rally in Fort Worth and ongoing fundraising efforts necessitated immediate intervention to prevent further harm to the state. The judge's order states that without the TRO, the state would suffer irreparable damage due to O'Rourke's fundraising activities. The order specifically prohibits the use of political funds for out-of-state travel, lodging, dining, or fines for unexcused Democratic lawmakers during special sessions. It also bans fundraising through platforms like ActBlue and prohibits offering or agreeing to provide such benefits as consideration for skipping sessions. Additionally, the order restricts the removal of any property or funds from Texas while the case is pending. Paxton's lawsuit against O'Rourke alleges that the former representative orchestrated a scheme to pay for quorum-breaking lawmakers' personal expenses, framing it as felony bribery and a violation of state election law. This aggressive legal theory could face significant challenges, particularly under the First Amendment, given that the Texas Deceptive Trade Practices Act is typically used to combat consumer scams rather than political fundraising. The quorum break Paxton is targeting is part of Democrats' broader strategy to block a Republican-backed redistricting plan. This move by Paxton is seen as an early victory in his legal campaign against the Democrats, but it's far from over. A hearing scheduled for August 19th will determine whether these restrictions remain in place while the case moves forward and whether Paxton's legal strategy holds up. O'Rourke, for his part, is not backing down. Just before the ruling, he took to social media to announce that he had filed a lawsuit against Ken Paxton in state court, signaling his intention to fight back. The specifics of O'Rourke's lawsuit have not yet been made public, but it promises to be a closely watched development. This case raises important questions about the boundaries of political fundraising and the role of the judiciary in regulating political activities. As the legal battle unfolds, it will be fascinating to see how these issues are addressed and whether the restrictions imposed by the TRO will be upheld. What do you think? Should political fundraising be subject to the same scrutiny as consumer scams, or does it deserve special protections? Share your thoughts in the comments.